Hello friends, so today we are going to talk about LOI. So I have prepared a case study on the subject and what is the legal understanding of LOI in the construction industry and what are its importance and what are the problems associated with LOI and what are the advantages and disadvantages of using LOI in our day-to-day business, and at the end we are going to discuss whether we should use LOI or not. So there are a lot many things we are going to cover on this subject, so stay tuned and thank you so much for joining us. So we are going to start. So the first question is, what is letter of intent? According to the dictionary of construction terms by Synome and building contract dictionary and building law encyclopedia, letter of intent are documents sent before entering into a contract from one party to another party indicating an intention to enter into a formal contract in the future. Such letters are usually sent by an employer, client, or main contractor to a prospective contractor, nominated subcontractor, or suppliers. So according to this definition, it is only an indication, and its indication and intention to enter into a formal contract in the future, which means so it may possible and may not possible we are going to enter into a formal contract or not. So this is very important point we have to understand very carefully. So in this letter we are only showing our intention whether we are going to enter into a contract or not in the future. Mainly it is an intention, nothing else, according to this definition. So next question we are going to take, why we use letter of intent. This is very important question. Why we use and why we issue letter of intent. In most of the cases, the employer cannot wait the additional few days necessary for the preparation and execution of a formal contract, so they simply issue letter of intent, LOI, to proceed for the work. If that is the only problem, it can be overcome by a simple letter of acceptance, LOA, of the contractor's tender rather than a LOI, letter of intent. But often there is something more substantial preventing the issue of letter of acceptance. It may be a delay in obtaining funding for the whole project from the bank or from the financing body. Or perhaps the tender was too high and reduction negotiations are in progress. So that's why client and employer don't issue letter of acceptance. They issue letter of intent. So the idea of letter of intent is straightforward. It tells the contractor that the employer is not in a position to enter into a contract for the work, but that work can begin and be carried out in accordance with the drawings and specification. If the employer has to stop the work, the contractor will be paid for what has been carried out. So our third question is, what are the problems associated with the letter of intent? The first problem is, there is no standard format for the letter of intent. It depends upon the person who is drafting the letter. So there is no industry standard format, so it creates a difference of opinion and it also creates many problems and errors as there is no standard format. It solely depends upon the person who is drafting the letter. So this is one of the most problematic issue. The second problem is, difficulties can often arise where the work proceeds and no contract is ever entered into. The parties are often in disagreement as to their respective rights and obligations. There have in the past few years been numerous referrals at great expense to courts for those rights and obligations to be established. The courts are left to examine the precise wording contained in letters of intent and to pick over the meaning, often with large sums are at stake. It is not surprising, therefore, that some judges have condemned the use of letter of intent because of uncertainty as to the intention of the parties as expressed therein. So if you'll Google it, you will find there are many judges who strongly condemned the use of letter of intent. So our third point is, what will happen if the letter is not properly drafted? The contractor commencing work may create a binding contract for the whole work on the basis of the contractor's tender, and also sometime court of law considered LOI as a full binding contract. Simply putting the words letter of intent in the letter heading does not produce a letter of intent. So we need to be very careful while drafting the letter of intent. Fourth point is, what will happen if the letter is properly drafted? It forms a simple contract on its own terms, and either the employer or the contractor can simply bring the arrangement to an end without notice. Means both the parties are free to run away without notice, as there is no formal contract. This can cause tremendous problem for the employer. For example, if the work has been proceeding under a letter of intent until the work is almost complete, for the contractor to walk away at that stage is very expensive for the employer. And the employer cannot claim damages for breach of contract, because it cannot be a breach for the contractor to do something which the letter of intent allows it to do. Means there is no formal contract, so both the party can run away. So there is no obligations, there is no roles and responsibilities defined in letter of intent, so both the parties can run away. So they are free, and this can cause a huge commercial damages. So we have to think on this perspective as well. Our fifth point, work done on a letter of intent is commonly valued and paid on the same basis as the contract that was envisaged in the tender. There is no golden rule about it. Indeed, the contractor is normally entitled to a quantum merit basis, or may be valued in several ways, but a payment must be fair and reasonable. But reaching an agreement of a fair and reasonable price for the work could cause a serious problem. Usually contractors don't agree with such valuations. They become very ambitious with a vague amount and high price, so employer always be in a negotiating position. For both the parties, payment is one of the most critical part in LOI. Our sixth point is, sometimes the letter of intent is so carefully drafted that both the parties are bound by it until the work is completed. Although that was almost certainly not the intention. Means they not intended to do so, but it was beautifully drafted and they bind by the contract. And it happens in many cases. So our next question is, what are the advantages and disadvantages to an employer and contractor in work being commenced on the basis of a letter of intent? Means what are the advantages and disadvantages using LOI? So first we'll discuss about advantages. Advantage is the first point. The main advantage of the use of a letter of intent is to allow work to commence earlier. The second point, the employer may gain a commercial advantage from the early start, but it could leave employer in a vulnerable position if the contractor refuses to sign the formal contract when it is presented. The employer is left with a dilemma. So there is no other option, and it will create a big issue. So the third point is, an advantage to each party is that if after the commencement events occur which seems that the contract is undesirable, either party can withdraw at any time. As there is no formal contract, both the parties are free to do so. Means there is no contract formed, so both the parties can freely run. So this is also an advantage for both the parties. If the condition and situation is undesirable and not favorable, both the party can run. So in my study and my research, I found only 3 advantages of using LOI, and I found many disadvantages of using this particular document, which is called LOI. So in the disadvantages section, we will take the first point. So the first point is, there is no standard format for the letter of intent, as we have discussed, and therefore they come in all shapes and sizes. There have been numerous legal cases where the wording of a letter of intent has been the subject matter of a dispute. So it becomes a dispute because the wordings are not clear, even terms are not properly defined and clear. So this definitely creates a dispute only. Our second point is uncertainty about the respective rights and obligations of the parties which have been created by a letter of intent. Means the parties are uncertain about their rights and obligations as there is nothing defined in the letter of intent. So we are going to discuss third point. So our third point is, the letter of intent may merely state that the contractor will be reimbursed its cost until a formal contract has been concluded. The contractor, if allowed to complete the project in the absence of a concluded contract, will be entitled to receive payment on a quantum merit basis. In other words, a payment which is fair and reasonable. Reaching an agreement of a fair and reasonable price for the work could cause a serious problem. And in the payment issue, there is one more problem, and that is, should the payment be based upon the contractor's cost or its tender price? This dilemma can often provide the contractor with a negotiating advantage, as in the absence of a binding contract, contractors often become more ambitious as to the terms under which they are prepared to carry on and complete the works. Our fourth point is, what will happen if the employer and client decide to replace the contractor or supplier? It is unlikely that the contractor will go willingly, and disputes as to the quality of work and payment will probably occur. Where a project has been commenced by one contractor and completed by another, and subsequently fault arise in the workmanship or materials, it may not be clear in whose work those faults originated. Again, this could lead to a serious disputes. Our fifth point is, contractors are usually delighted to be requested to commence work on a project. This usually means that the competition has been eliminated and the job is theirs. Commencement of work on a project by means of a letter of intent is usually seen by both the parties as a temporary arrangement, which will be short-lived until the contract is signed up. These short periods often go from a few days or weeks to many months. Payment often becomes a problem. In the absence of pricing amounts which will be paid to agreed stages, an undertaking to reimburse a contractor in accordance with its cost often leads to disagreements. So the payment term should be agreed and properly drafted in the letter of intent. In letter of intent, it will create a big issue later on. Further, the LOI may be no more than the expression of current intention and of binding effect in the case of Truff Construction Limited versus Regalia Knitting Mills 1971. So judge have given this decision and he says LOI may be more than expression of current intention and of no binding effect. Means there is no binding, it's only an expression and intention to enter into a contract in future. Or on the other hand, it may give rise to a binding contract to pay for part or the whole of the works. Refer to the case Monk Construction Limited versus Norwich Union Life Insurance Society 1992. In that decision, judge have clearly said it forms a binding contract upon the contract's terms, what has been mentioned in the LOI. So our final and last slide is, so advise on letter of intent for the future use in construction project or in any industry. So can we use it for the future or not? So my advice on the subject is, we should obtain an undertaking from the employer and client to reimburse the incurred cost of contractor if the work is terminated without a binding contract being entered into. So the contractor should ensure they will adequately get their reimbursement for expenses. The letter of intent should therefore be properly synchronized by contractors to ensure they will adequately get their reimbursement for the expenses so far. Because at an early stage of the project, contractors required subcontractors to commence work and major orders for the materials to be placed if completion dates are to be achieved. So there is also the matter of appointing person for the project. Such actions will normally involve major financial commitments and require an undertaking from the employer or client to reimburse the incurred cost of contractor if the work is terminated without a binding contract being entered into. So finally, as we understand that starting the work on the basis of letter of intent is not a good idea and it is clearly a recipe for litigation or dispute. So it is far better for an employer and a contractor to enter at an early stage into a formal agreement in the current FIDIC or other form accepted by both the parties. So my final suggestion on the subject and this case study, we should not use LOI. We should always avoid LOI to proceed the work. In case if you want to use LOI, you should take the above advice and you should consider the advantages and disadvantages while entering into a contract. During my research on the subject, I studied many books and I just want to refer some of the books. If you want to study further more on the subject, it is very good to study these books, especially 200 Contractual Problems and Their Solutions, 3rd edition, written by David Chappell, and Construction Contracts Questions and Answers, 3rd edition, written by again David Chappell. And there are other books as well: Building Law Encyclopedia by David Chappell, McEldoon and McElcloin, Building Contract Dictionary, 3rd edition, and I referred Dictionary of Construction Terms by Sinom Tolson. These are the books I have referred while doing this case study. So I hope you have learned something new. Thank you so much for giving your precious time and thank you so much for joining us. So please don't forget to subscribe my YouTube channel. Thank you and thanks a lot.